Fundamental liberties in Malaysia. The Constitution is not a mere collection of pious platitudes. It is the supreme law of the land embodying three basic concepts. One of them is that the individual has certain fundamental rights upon which not even the power of the state may encroach. They are set out in Articles 5 to 13 of the Constitution. There are 9 basic freedoms in Malaysia, namely Article 5, right to life and liberty, Article 6, no slavery, Article 7, no retrospective criminal laws or increases in punishment and no repetition of criminal trials, Article 8, equality, Article 9, prohibition of banishment and freedom of movement, Article 10, freedom of speech, assembly, and association, Article 11, freedom of religion, Article 12, rights in respect to education, Article 13, rights to property. So here we listing several cases or example from the article that have been issued at Malaysia before this.
Government of Malaysia and LAW245, the respondent had applied for an order directly the appellants to issue a Malaysian passport to and contended that he had a fundamental right to travel abroad and that the refusal of a passport violated this right. The court that even Article 5 itself does not confer on citizens a fundamental right to travel overseas. As for the protections against banishment, Malaysia had taken light positive by abolishing the Banishment Act 1959, which has not been applied since 64 years ago, since the case of Home Minister versus Chu Chon Yong and Anna. The recent issue on this basis is the amendment of Universities and University College Act (UUCA), which allows university students to hold position in both political parties and campus organization, which is a hot issue when students started complaining and showing their dissatisfaction that they should be given the same right to assemble and being given access to speak freely. Versus assembly done by the opposition parties is still a question of fact in whether the government has the right to restrict their movement or not. It can be deduced that the authority actually have power impliedly to decide whether such act is reasonable or dangerous and whether they will threaten the well-being and security of country or not.
In the cases, so in Halimatu Sa'dia binti Haji Kamarudin v Public Service Commission Malaysia and NR 15, the court rejected a woman's contention to be allowed to wear a burqa to workplaces because the government was entitled to abide a religious tradition that was optional in the interest of the public service. Next cases is the Fathul Bari Majahya v Majlis Agama Negeri Sembilan. It is strictly restricted under Article 11.4, which is stated that the propagation may be restricted to the Muslim, and not only the non-Muslim are restricted to this article, but even the Muslim are restricted to propagate and give religious talk to the public as they required tawliyah from the state. So here is the cases for the Article 12, rise in respect to education. So first, in Malaysia, primary education absolutely accessible to every person. This article also provides the basis of religious education where a person is not entitled to receive any instruction of other religion other than his own. For instance, for non-Muslim students cannot be forced to learn Islamic subject which is compulsory to the Muslim except he is voluntarily done so, as in case for the Tio Eng Huat v Qadi of Pasir Mas.
Bismillahirrahmanirrahim. Finally, based on Article 13, state right to property, Article 38 of Federal Constitution states that no person shall be deprived of property save in accordance with law. No law shall provide for the compulsory acquisition of use of property without adequate compensation.